Let's see, Mr. Rivello.
Yes. Candy Heath for the government.
And Matt Hennessy for the defendant.
Also appearing for the defendant, Matt Alford, Your Honor.
Right. And is the government ready to proceed?
Yes, Your Honor.
All right. You may call your first witness.
Government calls Nathan Hop.
And before I swear you in, I need to ask a question here. I've got a financial affidavit here, but I've also got appearances from Mr. Alford and Mr. Hennessy. So let's just get it on the record. Sir, do you need the appointment of an attorney?
No, ma'am.
All right, so you're able to afford your own attorney, and you have hired your own attorneys. Is that correct?
Yes, ma'am.
All right, thank you. You may have a seat. Come on forward. And please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in the matter before the court will be the truth, the whole truth, and nothing but the truth?
I swear.
All right, please be seated, and please speak up into the microphone.
Please state your name and how you're employed.
Nathan Hopp. I'm a special agent with the FBI.
Are you one of the case agents on the case of John Rayne Rivello?
Yes, ma'am.
Were you the affiant on the criminal complaint that was executed or issued by the judge on March 10th, 2017?
Yes, ma'am.
Does that criminal complaint provide for the offense of cyberstalking, which is a violation of Title 18 United States Code, Section 2261A? In this case, it'll be the 2A and B.
Yes, ma'am.
Approximately when did FBI get involved in the matter?
It was approximately two weeks before March 10th. So it would have been the end of February, approximately.
Did you receive information from Dallas Police Department with regard to the fact that this offense had been committed?
Yes, ma'am.
Were you able to review any evidence during that 2-week period prior to drafting this criminal complaint affidavit?
Yes, ma'am.
And what type of evidence in general were you able to review?
I was able to review search warrant returns from DPD that were obtained from both Twitter and Apple, as well as information obtained from AT&T and information provided by the victims themselves.
Was an individual identified in this matter as the defendant?
Yes, ma'am.
Could you please describe the offense as you saw it from or saw it from the evidence that you obtained?
Yes, ma'am. On December 15th, 2016, John Rivello sent a tweet from a Twitter account that he owned at Jew_Goldstein to the victim. This tweet contained a message that said, "I hope you have a seizure" for your post, and then contained a strobing image known as a GIF or GIF. Upon viewing this GIF or this tweet, the victim immediately suffered a seizure, an epileptic seizure. The victim's wife is a medical professional, walked in, saw him having the seizure, and then took a picture of the tweet still on his computer, still flashing, and then called 911 and reported the incident as a complaint. DPD started investigating the incident and sent a search warrant to Twitter for the account Jew_Goldstein. From the information that Twitter provided, among other things, was a telephone number associated with the account. from that telephone number, they sent AT&T a subpoena requesting information related to the telephone number. AT&T responded with with information showing that the telephone number is associated with an Apple iPhone account. DPD then took that information and sent Apple a search warrant for information related to the telephone number and the Apple iPhone. Apple then responded with information saying that the account was owned by John Rivello, and further information in there indicated it was owned by Mr. Rivello, to include pictures of him holding his driver's license up next to his face. Other things included in the iCloud account were a screenshot of the tweet that was sent to the victim with the victim's Twitter account on there, the actual strobing image or GIF that was sent, as well as a fake obituary concerning the victim and the incident, and then several anti-Semitic rhetoric, for lack of a better term.
From the investigation, was it determined whether or not Mr. Rivello knew that the victim had epilepsy prior to sending this strobe GIF?
Yes, ma'am. In reviewing the information provided by Twitter, he had several direct message conversations with other individuals. In some of those direct message conversations, he stated that he knew the victim had epilepsy before. He also stated that he had been sending him tweets every day for months, and it wasn't until he sent this gift that he got a response from the victim.
Were the tweets that were being sent to the victim, were they harassing the victim in any way?
I'm not sure.
Have you talked to the victim about the nature of some of the tweets that he received from Mr. Rivello?
I do not recall.
Did the direct messages that you reviewed for Miss... I don't know if it's this microphone or... In any of the direct messages that you reviewed for in Mr. Rivello's account, did it show that he had talked to other individuals about having harassed having harassed the victim in the past?
Yes, ma'am. In several of his direct messaging conversations, he had made mentions to the fact that he disliked the victim and said a lot of anti-Semitic things about the victim.
Was there any indication as to what religion he believed the victim to be?
I believe the victim was Jewish.
And in fact, is the victim Jewish?
No, the victim is not.
But the defendant believed the victim to be Jewish.
Yes, ma'am.
Were there other individuals with whom the defendant communicated on direct messages that also believed the victim to be Jewish?
Yes, ma'am. Everybody in his direct message conversations believed that he was Jewish.
This strobe gift that caused the victim to have the seizure was sent to the victim on December 15th, 2016, correct?
Yes, ma'am.
The account at Jew_Goldstein that was set up by the defendant, was that set up just a week before that gift was sent to the victim?
It was set up days before. I don't even think it was a full week.
Was the gift that was sent to the victim something that the defendant had downloaded from the internet?
It appeared it had been downloaded from the internet, yes.
Now, have you had an opportunity to review an email that was sent to the victim that purported to be from the defendant?
Yes, ma'am.
And is this what has been referred to as the apology email?
Yes, ma'am.
In this email, did the defendant admit to sending the tweet?
Yes, ma'am.
You recently arrested the defendant, is that correct?
Yes, ma'am.
And when was that?
It was last Friday, March 17th.
Did you have an opportunity to talk to the defendant during the time that you arrested him?
Yes, ma'am.
Was that talk brief? Or
Yes, ma'am.
During that period of time, did the defendant make any statements to you at all with regard to this incident?
Yes, ma'am. The defendant, Mr. Rivello, stated that he did send the gift to the victim, and he actually sent it to him. He stated multiple times around the same time, as well as other tweets around the same time he sent the gift.
Describe the seizure that the victim had and what repercussions occurred after that.
The victim had an epileptic seizure, and due to the seizure, he experienced another follow-on seizure, and during the seizure he lost all cognitive control of his body and memory. For a day or two afterwards, he suffered a loss of mental ability, for lack of a better term.
And did the Dallas Police Department actually talk to the victim's neurologist to determine that the strobe gift, in fact, was a factor in the seizure that the victim had?
Yes, ma'am. The neurologist stated that it was the gift that induced the seizure, and because of that, the victim was likely to have follow-on seizures.
And are you aware that the victim has had additional seizures since that time?
Yes, ma'am. According to the victim's wife, he woke up in a state that could only be caused by having another seizure within a few days of having the first seizure.
Now, the victim had filed a civil suit in order to try to determine the identity of the individual that sent the tweet. Is that correct?
That's correct.
And in that lawsuit, did the defendant actually file something anonymously discussing his sending of the tweet?
That's correct.
In that affidavit, did the defendant identify himself?
No, defendant did not.
Did he just identify himself as a John Doe and reference the tweet or the Twitter account, Ari Goldstein?
That is correct.
And in that affidavit, did the defendant basically deny all intent to harm the defendant? Harm the victim.
That is correct.
Did he spend some time in that affidavit explaining that he didn't create the GIF, that he actually just downloaded it from the internet?
Yes, ma'am.
Now, upon the arrest of the defendant, he appeared in court in Maryland. Is that correct?
Yes, ma'am.
And the government did not move to detain him, but terms of his release were agreed upon. Is that correct?
Yes, ma'am.
So there is no issue before this court about detention at this time?
No, ma'am.
And just for the purposes of the record, is the individual that you arrested and that admitted to sending the gift to the victim here in the courtroom?
Yes, ma'am.
And where is he in the courtroom?
He is seated over there to your right, ma'am.
Okay, well, there's several people over to my right. Which one would he be?
He is the third one to your right, the dark hair.
Your Honor, may the record reflect that the witness has identified the defendant in open court.
The record will so reflect.
And we would pass the witness.
Cross-examination.
Thank you, Your Honor. So, Agent Hop,
Yes, sir.
my name is Matt Hennessy.
Sir.
Nice to meet you. So, I don't want to identify the victim by name, but perhaps just set a little context for things. The victim is a public figure, perhaps known for taking public positions on TV shows and the like, political positions.
Yes, sir.
And his politics, let's say, he's not in favor of our current president. Is that fair?
Yes, sir.
And he makes frequent appearances on television.
Yes, sir. Several times.
Are you aware that Mr. Rivello is a former Marine?
Yes, sir.
Are you aware that he retired as a sergeant?
I was not aware of that.
And that his duty while in service in Iraq and Afghanistan was as a mortuary affairs specialist?
Yes, sir.
Do you know what? Were you ever in the military?
No, sir.
Do you know what a mortuary affairs specialist does?
Yes, sir.
Tell us.
They dispose, or they, that's a bad word to say,
Preserve.
they preserve or prep deceased bodies. Oftentimes our own soldiers to be transported home.
He collects his comrades, his fallen comrades, to bring home so that their families can honor them.
Yes, sir.
Are you aware that he has been diagnosed as having some mental disabilities on account of his service in Iraq and Afghanistan?
Yes, sir.
And just prior to this, just prior to the tweet that was sent by Mr. Rivello on December 15th, 2016, just prior to that, you're aware, aren't you, that this public figure, this victim, had been on TV criticizing the coming administration. By then, we did not have President Trump, it was still President Obama, but he was on television criticizing the coming administration.
Yes, sir.
Ms. Heath also mentioned that Mr. Rivello was released on bond. You're aware, aren't you, that he was released into the custody of his father?
Yes, sir.
And his father is a retired DEA agent, 28-year veteran from the DEA.
Yes, sir.
Now, as to the meat of the complaint, have you interviewed the victim?
Yes, sir.
On how many occasions?
Just once, sir.
When was that?
I can't recall the exact date.
Well, the complaint was filed March 10th.
Yes, sir.
You said you were involved sometime 2 weeks before that, so it had been within the 2 weeks prior to March 10th?
Yes, sir.
Did you prepare a report from that interview, to be specific?
No, sir.
Any notes?
Yes, sir.
Do you have those with you?
No, sir.
Where are those?
Those are at my field office.
All right. Judge would ask those to be produced at some point.
At some point before we finish this hearing, or at some point?
I'll withdraw that, Your Honor. So when you interviewed the victim, did you discuss how he received this tweet?
Yes, sir.
And let me understand this. What I heard you say, and I want to make sure I'm clear here, is that what I heard you testify to is that Mr. Rivello had been sending this same GIF on multiple occasions in the past, and he finally got a response?
According to Mr. Rivello, what he said was that around the same time he sent the gift that caused the seizure, he sent the same gift several times and several tweets.
Did he tell you within what period of time those several tweets were sent?
No, sir.
All right. How did you interpret it? Within a series of minutes, or a series of days, a series of weeks? What did that mean to you when he said what he said?
To me,
Yes.
I took it to mean within a few days.
But from speaking with the victim, when I've heard from you, there were several sent. Were you able to figure out which one the victim opened? One first sent, one last sent, someone in the middle? Were you able to determine that?
I don't know, sir.
Were you able to determine whether, if there were multiple tweets sent with the same gift, whether more than one was opened?
I have not been able to determine that yet.
Did you discuss with the victim, do you know what autoplay is?
Yes, sir.
What is it?
It's when you receive something, it just automatically starts playing. You don't have to interact with it.
And you know that there is a way to turn that off, to disable autoplay.
Through the course of the investigation, I have found that out.
Did you speak with the victim about whether autoplay was enabled or disabled when when he observed this gift?
The victim stated that the autoplay at that time was on.
Was on?
Was on. He was not aware that there was such a feature until after the incident.
Okay, so the autoplay was not disabled.
Correct.
Which means, just for the record, so as soon as the tweet would open, in theory, the gift should automatically play.
Correct.
And it's autoplay.
Correct.
The victim told you that well, did he? Let me ask it that way. Did the victim tell you that he immediately had a seizure upon opening or seeing that open gift?
Yes, sir.
You said his wife witnessed it?
Yes, sir.
What did she witness?
She saw him. Saw him laying on the ground, having a seizure. And when she looked up, she saw the actual GIF still strobing on the screen.
Did anyone else besides his wife witness the seizure?
Not that I know, sir.
Did I hear you say 911 was called?
Yes, sir.
And have you listened to the 911 tape?
No, sir.
Have you interviewed any of the EMTs who showed up? Well, first, did any EMT show up?
No MTs came.
Why?
From my understanding, the wife did not request an ambulance.
The wife did not request an ambulance.
That's right. Yes, sir.
All right. Your complaint, or the government's complaint, I should more properly say, talks about, and it's one of the elements is serious bodily injury.
Yes.
All right. So the victim's wife waved off the ambulance from coming to the house that night, correct?
Yes, sir.
Do you know when the victim went to the doctor next?
I can't recall when he immediately went.
Now, to serious bodily injury, what, in the course of your investigation, what have you found as to serious bodily injury with respect to this victim?
The seizure itself is the loss of memory, the unable to control your body. Those would be the serious bodily injuries.
So that's what you say serious bodily injury is loss of memory and the seizure itself?
I can look up the definition, and then that would probably let me speak to it a little bit better. I have it in front of me.
Oh, okay. Pardon me, I didn't know that. Please go ahead.
So it says here, serious bodily injury is defined as any bodily injury which involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental facility.
So in what part of that list does loss of memory fall?
Mental faculty.
And what about the seizure itself? What does that fall under?
I would say, I'm not a medical professional, but I would say protracted loss or impairment of bodily function.
Well, you said that he lost memory of the event itself, correct?
Yes, sir.
And he had some difficulties in the following days and even a follow-on seizure.
Yes, sir.
So for how long did he suffer this protracted loss?
I'm not sure, sir.
Were you aware that he was on television the following week giving interviews?
I was aware that he was publicly publicly talking about the incident, yes.
Have you personally talked to any of his doctors?
No, sir.
Do you have permission to talk to any of his doctors?
I'm not sure if I've even asked yet, sir.
Do you have any of his medical records?
No, sir.
Have you consulted an expert as to what the effects of a seizure are?
We have a sworn affidavit from his doctor.
You have a sworn affidavit from his doctor?
Yes, sir.
Did you have that before you prepared your complaint?
Yes, sir.
Do you have that sworn affidavit with you?
I do not, sir.
Where is that?
That would be at my field office as well. That was obtained from DPD.
From Dallas Police Department. Do you know when that affidavit was prepared?
I can't recall, sir.
Did you happen to investigate whether there were any risk factors in play when the event occurred? Risk factors for seizure. Do you even know what I'm talking about? A risk factor for seizure.
Can you explain that a little more?
Sure. So a risk factor for seizure could be a lack of sleep, going too long without a good night's sleep, or perhaps even the recent overuse of alcohol. Or even stress. Did you investigate whether any of those known risk factors for seizure were present on December 15th at the time that this gift opened?
I did not.
Is there anything about that, about risk factors in the affidavit that you read from the doctor, the neurologist?
I don't recall.
Are you aware of the particular? Are you aware of the name? Have you heard of photosensitive epilepsy?
No, sir, but I can infer what it means.
Sure, it's what we're talking about here. That a person in whom seizures can be brought on by observing certain patterns of flashing lights.
Yes, sir.
Did you do any investigation? Did you ever try to discover how rare that is?
Did I ever try to discover how rare it is?
Yes.
No, sir, I did not.
Now, this particular gift that was sent, it came out on direct. I think what you said was that Mr. Rivello said that he didn't create this gift, he found it on the internet.
Yes.
Right? And you found that to be true.
Yes, sir.
Not only did you find that to be true, in your research you probably found other gifts just like this floating around out in the ether, didn't you?
Yes, sir.
This particular gift, you know when it was created?
The particular gift that
Sent to the victim. Does 2012 or even 2008 sound right?
that I have seen those dates, or the 2012 data.
2012, I've seen two. Thank you. And so, again, no evidence whatsoever Mr. Rivello created that.
Yes, sir.
That is, there is no evidence.
Yes.
Thanks. You mentioned the screenshots. So, in getting your orders and warrants, you got a hold of information from Mr. Rivello's iCloud, right?
Yes, sir.
And on that iCloud, you found screenshots of various things that are mentioned sort of at the end of your affidavit for complaint, correct?
Yes, sir.
Did you investigate whether Mr. Rivello actually created the content of those screenshots?
With the information I had, there was no way to tell, sir.
Okay, so said differently, there's no evidence whatsoever that he created the content of the screenshots that you found on iCloud
That's correct.
weeks and months after the event.
Yes, sir.
Just one moment, Your Honor. Did you make a report? How many people have you interviewed in connection with your investigation in this case?
I believe just two, sir.
And who are they?
The victim and Mr. Rivello.
So it sounds like what your complaint is based on, is it just based on what Dallas Police Department handed you?
A good portion of it, yes, sir.
Well, everything except what the victim told you.
Yes, sir.
Pass away, Your Honor.
Any redirect?
Yes, Your Honor. Agent Hopp, the elements necessary for a 2261A case provides that the defendant with intent to kill, injure, harass, or intimidate used a communication system of interstate commerce. Is Twitter a communication system of interstate commerce?
Yes, ma'am.
And did you find any chats or any direct messages indicating what the intent of the defendant was in sending that gift?
Yes, ma'am.
And what did you find?
I found the intent was to injure the victim based on his outlook on his outlook on his political stance, and also his supposed Jewish faith.
The gift that was sent, did that, from your discussion with the victim, did it place him in reasonable fear of death or serious bodily injury?
Yes, ma'am.
And in fact, did he suffer serious bodily injury as a result of the gift?
Yes, ma'am.
And when you're saying serious bodily injury, it caused him to have serious impact on his ability to even move his body during the seizure, is that correct?
Yes, ma'am.
He lost all control of his bodily functions,
Yes, ma'am.
and he lost all control of his mental faculty.
Yes, ma'am.
Was he basically out of it and not coherent during the period of time of the seizure.
Yes, ma'am.
Was it determined that he actually suffered a second seizure that night while he was sleeping?
Yes, ma'am.
And that's according to his wife, is that correct? Did the seizure cause he, his wife, or his sons any emotional distress?
Yes, ma'am.
Can you explain a little bit about what they have gone through since that period of time, since receiving the gift and that caused the seizure?
The family has continued to get follow-on tweets with strobing images in them. They've been harassed because of this incident. It's caused them a lot of distress. The victim stated during the holidays, I mean, he wasn't really there even. He had to be fed. He couldn't raise his arm. It was pretty awful for their family.
Have there been adjustments since December on a fairly regular basis to his medication for trying to prevent seizures?
Yes, ma'am.
And was there some indication that, based on the seizure that he had from the strobe gift, that those medications are reduced in their efficacy, their ability to actually help him?
Yes, ma'am.
And does that cause emotional distress for the victim and his wife and family?
Yes, ma'am.
You were asked about the risk factors for somebody with epilepsy to reacting to a strobe light, correct?
Yes, ma'am.
Did you find those risk factors actually on a screenshot on the defendant's iCloud account?
Yes, ma'am.
Your Honor, we pass the witness.
Just very briefly, Your Honor, thank you. You mentioned that Agent, you mentioned that after this event, he started to get other tweets sent to him of a similar nature.
Yes, sir.
But it's also true, isn't it, that within the week after this event, he went on TV and told the world that someone sent him this flashing gift, right?
I'm not aware if he actually went on television, but I know, yes, he
put it
in
out there.
social media at least, he blasted that out there.
He put it out publicly one way or another.
Yes.
And you talked about looking at Mr. Rivello's tweets and communications that were obtained via warrant or court order.
Yes, sir.
And I'm not here to make excuses for every one of them, but is it fair to say, looking at them as a whole, much of it is evidence of the coarse political discourse that we see all too much of today?
What do you mean by that?
Angry people, angry about
Your Honor,
politics.
we object to speculation on the part of this witness. There's no basis for asking that particular question.
Well, I'm not sure how it goes to probable cause.
Very well, Your Honor. That's all, Your Honor. Thank you.
You may step down. Thank you very much. Anything else from the government?
Government rests, Your Honor.
All right. Anything from the defense?
No, Your Honor. Thank you.
Do the parties wish to present argument?
None from the defense, Your Honor. None from the defense, Your Honor.
Your Honor, I believe the criminal complaint speaks for itself in this case, and we would rely on the criminal complaint as our final argument.
Based on the testimony before me, I do find probable cause in this case. So, Mr. Rivello, you will have to face further proceedings in this case. We are adjourned as this matter. Counsel are excused if they have no further matters before the court.